A number of proposals have been introduced at the state and federal levels to ban employers from imposing non-competes on their workers. So how would this affect the IP rights of employers and workers? In theory, none of the proposed bans seek to limit the ability of employers to enforce their IP rights. But practically speaking, a ban on non-competes could make it more difficult for an employer to prevail in an IP-related dispute with a former worker if that employer hasn't been diligent in preserving its IP rights. As an employer, there are a number of steps you should take to ensure you're protected. You should be very specific in defining categories of confidential and proprietary information in your employment agreements and agreements with your contractors. If you retain a non-compete provision in your agreements, then the terms that prohibit workers from using your proprietary information should not be mixed in with that non-compete provision. So far, all of the proposed bans on non-competes specifically exclude NDAs, so you should make greater use of them. Consider having contractors execute a separate NDA, instead of just including your NDA terms in your contractor agreement. Lastly, make sure that you clearly identify and label all documents and materials that include trade secrets. As a worker, you should be aware that a ban on non-competes wouldn't necessarily mean that you can now exploit the IP you created on behalf of past employers or clients. Thanks for watching Kilobytes. For more, follow us on LinkedIn and Medium. I'm Sabr Ibrahim of OptimEdge Legal.